Welcome to today's program titled Joint Venturing and Teaming for Federal Set-Aside Contracts. My name is Randy Evans. I'm an attorney in private practice, and I also serve as the chair of the Tribal Telecom Conference Advisory Council. I'll be your host for today's program. Our speaker today is Steve Koprince, an attorney in private practice focusing on government contracting and business law. Before we begin today's program, I'll take a couple minutes to provide some background about Tribal Telecom and this webinar series. The annual Tribal Telecom and Technology Conference brings together American Indian and Alaska Native communities with the telecom and technologies industries, and really serves as a gathering place to share information, explore solutions, and create new possibilities for pathways across the digital divide in Indian country. Key focus areas of the conference include community and economic development, culture, education and government, public safety, emergency management, and health. Our fourth annual Tribal Telecom Conference will be held in Albuquerque, New Mexico, May 4th through 7th of 2015. We're honored to have an A-list lineup of keynote speakers, including Shirley Bloomfield, President and CEO of NTCA, the Rural Broadband Association, Beta Ildrum, who's a Senior Vice President with Intel Labs, who will be speaking about the Internet of Things, and Tracy Morris, who was recently appointed as Executive Director of the American Indian Policy Institute at Arizona State University. Following this last year's conference, we received a number of requests for year-round education opportunities that expand on and supplement the topics discussed at the annual conference. The Tribal Telecom webinar series marks the beginning of our efforts to respond to those requests. As for today's program, Steve is going to speak for about around 40 minutes, and then we'll have time for questions after his formal presentation. If you do have questions during the presentation, you can use the question box on the webinar toolbar. You can type your questions in during the program. If your question relates to a specific point that Steve is discussing, then we'll address the question at that time. Otherwise, if it's a more general question, then Steve will address it at the end of the formal program. Our presenter for today's program, as I said earlier, is attorney and author Steve Koprince. Steve is a partner in the Kansas law firm of Petefish, Immel, Heeb, and Hurd, and he focuses his practice on government contracts and small business law. He's the author of the Small Business Guide to Government Contracts and has published a number of articles on government contracting. You can find more information about Steve on his law firm's website, which is petefishlaw.com, and also on the website smallgovcon.com. That's smallgovcon.com. Steve's contact information is also available at the end of this slide presentation. And with that, I will now turn the conference over to Steve.
Well, great. Thank you, Randy, and thank you, Tracy, for hosting today's event. And thank you to everyone for spending a little time in your afternoon to learn a little bit about joint venturing and teaming on federal set-aside contracts. And now this is a topic that I could probably talk about for 3 or 4 hours if push came to shove. There's a lot to talk about here. This is going to be more of a condensed topic. If you do have questions, as Randy said, feel free to ask. And if there's a need for anyone to speak with me briefly offline, I'll try to make myself available for that as well if it's just something we can't get to during the presentation. But I do want to get started and let you know what we're going to be talking about today. Here's our presentation overview. First thing I want to talk about, joint ventures versus teams. You know, these concepts are often spoken about in the same breath. Joint ventures, teams, they're not the same, though. They're actually quite different in how they're set up, when one form or the other might be more advantageous, and in some cases when one form or the other might be workable within the regulatory framework or simply not work. So we'll talk about the characteristics, legal forms, capabilities, and the size requirements, because we're talking here about set-aside contracts. And so anytime you're talking about a set-aside contract in the federal arena, you need to ask questions about whether the teaming arrangement you're going to form is going to qualify that company as small for that set-aside contract. So we'll talk about those items first. Then spend the next portion of our of the presentation talking specifically about joint ventures. How do you go about forming a joint venture? I mean, that's the number one thing you want to consider. What sort of things should be in the back of your mind? Specific joint ventures are going to have actually required provisions. There are regulations that require you to insert specific provisions in your joint venture agreement. I'll go over some of those in this presentation. I won't read them. I'll read them all word for word for you, but tell you where to find them if you're going to be forming a joint venture that has some of those mandatory provisions. Those are the mandatory provisions. We'll talk about what else you really ought to consider including in the joint venture agreement. Just including the mandatory provisions and nothing else may get you to a place of compliance, but it may not be the most beneficial arrangement between two teammates. We'll talk about subcontracting limits when you're a joint venture. How does that work? Special rules within the 8A program, which often tribally owned companies or companies owned by Native Americans or Alaska Natives are either 8A qualified or interested in becoming 8A qualified. So we'll talk specifically about the 8A rules for joint ventures. Next part of the presentation, we're going to talk about the prime subcontractor teams, talk about that separately. Again, how do you form one of those? What's a teaming agreement? We'll talk about that. What do I recommend be included in a teaming agreement? We'll talk next about subcontracts, which is not the same as a teaming agreement. We'll talk about the differences between the two, what should and perhaps should not be included in a subcontract. What are the subcontracting limits on the set-aside contracts? That's actually something that's in a little bit of flux right now. I want to let you know about that. We'll talk about, you often hear on set-aside contracts about ostensible subcontractor affiliation. That's a term that gets thrown about a fair bit both inside and outside of protests. And so talk about what that is and how you can structure your team to avoid it. And so without further ado, I would like to get started. Again, rather compressed time today. I want to make sure we get to the meat of the presentation. Let's talk about joint ventures versus teams. First of all, they are two separate concepts. And here the FAR doesn't really do us any favors here. If you go to the FAR kind of lumps joint ventures and teams together under the heading contractor team arrangements. It just says, contractor team arrangement could be a prime sub team, it could be a joint venture. Doesn't really provide you any great detail as to what the differences might be. But when you actually turn to the SBA's regulations, and in the set-aside world, the SBA is a very important agency because they regulate who qualifies as a small business for all these contracts. The SBA does much more carefully define the differences between prime sub teams and joint ventures. And so, and these terms, by the way, also can be defined, or at least the differences can be found just by looking at common law of various states as well, because joint ventures and prime subcontractor relationships, of course, are not limited to the government context. These sorts of arrangements can be formed in the commercial context as well. So first, conceptually, at a big picture level, when you've got a joint venture, both parties, we'll assume it's a two-member joint venture. A joint venture could have 3, 4, once I formed a JV with 5 members, but we'll assume it's 2 because that's the most common. Both parties to that joint venture are prime contractors. They both have a direct relationship with the government. In contrast to the prime subcontractor team setting, only the prime contractor has that relationship with the government. The prime contractor is now in more of a hierarchy, or it is in a hierarchical relationship with the subcontractor. This prime contractor is the boss, supposedly. Subcontractor serves underneath the prime. They're not equals anymore. In a joint venture setting, the parties typically split profits and losses, and you can see that this flows directly from the concept that everybody's a prime contractor. Everyone's a prime contractor. Everyone's responsible for finishing the whole prime contract, and so if that contract produces a profit, that the joint venture partners will split that. If there are losses, then they'll have to divvy those up as well. In contrast, the subcontractor is typically paid on some sort of fixed basis. The reason being the subcontractor is not responsible for performing the whole contract. It's only the sub is responsible for performing a certain scope of work, a portion of the prime contract. And so that sub may be paid on a fixed price formula, just a lump sum. We're going to pay you $1 million subcontractor to do this particular scope. Maybe paid on a fixed formula basis, and by that I mean a labor hour basis, time and materials, some formula that is prearranged that allows the subcontractor to get paid in a way that's not dependent on whether the prime contract as a whole generates a profit for the prime contractor. In the joint venture setting, you will see it's very, very common. Most joint ventures these days are formed as limited liability companies, separate legal entities. That means articles are actually filed with the state government. You don't see that in a prime sub-team. Both parties maintain their own corporate identity. You're not forming an LLC or any sort of separate legal entity to do a prime subcontractor team. Finally, as a joint venture, the subcontracting limits, we'll talk about those a little later in the presentation. The subcontracting limits apply to the joint venture as a whole. Everybody's a prime contractor, so if there are 2, 3, 4, 5 prime contractors in that joint venture, they all can share the requirement that the subcontracting requirement limit. In contrast, of course, in a prime sub-team, the subcontractors' work generally will not count toward the prime's own work. However, there are now, Congress has actually passed an exception to that. I'll talk a little bit about that in my limitation on subcontracting piece. So if you are interested in setting up a team type relationship, you're not sure which way to go, one deciding factor is often, well, the size issue, because joint ventures and prime subcontractor teams are looked at very differently by the SBA in determining whether the prime contractor qualifies as a small business. And so the basic rule for a joint venture, and this again flows from the concept that every member of the joint venture, both members, if it's a 2-member joint venture, are prime contractors, the SBA will typically add their sizes together because everybody's a prime. So if you've got a $5 million business and a $20 million business, the SBA says that joint venture is a $25 million business. And that size stats will determine whether the joint venture qualifies as small for a particular procurement. In contrast, you've got a prime sub-team. The SBA only looks at the size of the prime contractor, except in the case where the ostensible subcontractor rule has been violated. And I'll talk about that at the end of the presentation. But generally, in a prime sub-team, only the prime size counts. So that means, essentially, bottom line here, that if you're going to do a joint venture, you've got to do it, and you want a joint venture with a large business, you're out of luck, except in a very limited context of an 8A mentor protege joint venture. And I'll speak very briefly to that. But outside of that setting, if your prospective teammate, if you're a small business and your prospective teammate is large, well, you already know which of these forms you're going to be using. You're going to be using the prime sub-team because you cannot joint venture with a large business for a small business set-aside contract. It just doesn't work. Now, the SBA does have one exception. This is when 2 or more joint ventures, or excuse me, 2 or more small businesses want to joint venture together. The SBA has a rule called the individual size treatment rule. I call it that. That's not what the SBA calls it. But it's there in the SBA's regulations, and you can see when this rule applies. But basically, when there are procurements that are sufficiently large where the SBA thinks, well, it would be nice to give these small businesses more of an incentive to form a joint venture, the SBA, instead of adding the sizes of the joint venturers together, will look at each company separately and compare that company size to the size standard. So again, that's a special benefit to multiple small businesses who want to form joint ventures. It may allow 2, 3, 4 small businesses to joint venture together and not have their sizes added together, which could be a definite benefit. However, this rule, this individual size treatment rule, still does not allow a small business to joint venture with a large company for a set-aside contract, because even if you look at the large business individually, its size alone exceeds the size standard. You see at the bottom the 8A mentor project program, and again, we're talking about companies that are certified by the SBA and the 8A Business Development Program, which many tribally owned businesses or businesses owned by Native Americans, Alaska Natives, Hawaii Natives are certified in the 8A program. There's a special benefit to the 8A program in which a certified 8A participant can enter into a mentor-protege agreement with another business, including a large business, and the mentor and protege may joint venture for any small business or 8A contract, notwithstanding the fact that the mentor is a large business, based only on the size status of that 8A protege. So you could theoretically have, for example, a contract set aside under a $7 million size standard, and you've got a joint venture consisting of a $5 million 8A company and a $500 million mentor company. Ordinarily, that joint venture would not even be able to sniff eligibility on that contract. Wouldn't even be close. But within the context of the 8A mentor project program, that joint venture actually could be eligible, provided the joint venture agreement complied with the appropriate rules. And so it's a really powerful benefit of the 8A program, and it's possible that this benefit might be extended to women-owned businesses, hub zones, and service-disabled, veteran-owned small businesses in the future. It's not clear. Congress has authorized the SBA to extend it. But for right now, only the 8A members and proteges can take advantage of this large, small joint venture. It's a powerful benefit of being a part of the 8A program. So what is a joint venture? We talked about a joint venture being 2 or more companies. It could be more companies. In a joint venture, typically each party combines its resources, skills, efforts, and knowledge. They do share the profits and losses, as I mentioned. That's typical because every member of the joint venture is responsible for the whole prime contract. Importantly, on this fourth bullet here, the SBA considers a joint venture to be a temporary entity. A joint venture under the SBA's rules is an entity that bids on 1 or 2 or 3 contracts, maybe wins a couple contracts, and then ceases to exist. It's not a long-term, it doesn't have long-term existence. It's not a long-term relationship between the companies. And so there's a specific rule that you may have heard about called 3 and 2. And the 3 and 2 rule has changed over the years. But what the 3 and 2 rule says is that if the members of a joint venture win more than 3 contracts, are awarded more than 3 contracts over a 2-year period, if the joint venture is awarded more than 3 contracts over a 2-year period, the members of that joint venture may be deemed affiliated for all purposes. In other words, the SBA may say essentially, we think you guys are doing so much business together with this joint venture that we're going to deem you, affiliates for all purposes, no matter if you're joint venturing together or not on a particular contract. So you got to be aware of the 3 and 2 rule. I've frequently said that the 3 and 2 rule is the stupidest rule in government contracting. This is my personal opinion. Because it's so easy to avoid. The way to avoid 3 and 2 affiliation with a joint venture partner is simply to form a new joint venture with that same partner. And so you sometimes will see contract awards being made to company JV1, JV2, JVA, JVB. That's why these partners are forming new joint ventures in order to avoid the 3 and 2 rule, and it works. SBA has said you can do that. So this rule exists. You got to be careful for it, but in my opinion, it's really it's a dumb rule. It's almost essentially just a gotcha for people who don't know the 3 and 2 rule, which is not a wise regulation in my opinion. So we talked about how most joint ventures are formal legal entities, typically limited liability companies. You could theoretically do one as a corporation or some other form of corporate entity, but typically LLCs, by virtue of their flexibility, ease of formation, lack of corporate formality requirements, etc. LLC is the preferred format. A separate legal entity is not going to be required to form a joint venture for most procurements. You could form it what's called a joint venture by contract or just a partnership joint venture, no filing with the state government. Contracting officer may scratch their head a little bit because they're so used to seeing LLC joint ventures, but it's doable. It's not non-compliant. If you are going to go after a VA SDVOSB set-aside contract with the Department of Veterans Affairs, the VA has said that they actually require you to form a separate legal entity. But usually in this joint venture by contract, an informal JV is permissible, although not necessarily advisable. Now, joint ventures can be populated or unpopulated. And again, if you're familiar with joint ventures, you've probably heard these terms. A populated joint venture is simply an entity that has employees of its own. And so the joint venture is formed. It's a limited liability company, for example. And now each member of the joint venture starts moving employees onto this JV's payroll. The JV has its own payroll, has its own pays salaries, pays offers benefits, pays unemployment insurance, tax, all those sorts of things that a typical company would. It acts for purposes of the contract as its own separate company. It is a company. It's a legitimate company performing the contract with its own people. The downside of the populated format that most of my clients have found is that it's not very realistic to create. I mean, a joint venture is supposed to be a temporary entity, so now you're trying to move employees from 2 different companies into a 3rd company. The differences potentially in salary and benefits. Surety companies may have problems with, insurance companies may have problems with this new company. And so there are issues that are in the formation of a populated joint venture that tend to pop up that make people think twice about using that format. It's doable, but I think I saw somewhere, and don't quote me on this, but they said only 2 to 3% of government contracts, JVs, are populated, and that sounds about right. Most of the ones that I've scene are unpopulated. An unpopulated joint venture is a joint venture that does not have its own employees. It is a legal entity, typically an LLC, but it acts through its members. It's a legal fiction. The joint venture is simply essentially a pass-through for its two members or multiple members if there are more than two. And that's just fine. That's just what an unpopulated joint venture is, a legal fiction that allows two or more companies to collectively act as the prime contractor for a government contract. Perfectly permissible to do it that way. A few other things to think about if you're forming a joint venture. How are you going to manage the joint venture? That question may be in some part answered by the regulations. If you're going after a socioeconomic set-aside such as 8A or women-owned or service-disabled, the regulations will tell you something about how you need to manage it, but there's still some wiggle room within those regulations. Who's going to provide what in terms of facilities and resources? Who's going to be the project manager? Some of the socioeconomic regulations, again, will require you to name a specific member's employee as the project manager. Who's going to provide what in terms of key employees? Is the joint venture going to have subcontracts? In many cases, these items are not going to be required if you're not going after a socioeconomic set-aside. They're still wise to consider and insert in your joint venture agreement, however. As far as we talked about joint venture agreements, the required contents do vary by program. If you're just going after what I'll call an ordinary small business set-aside, that is a set-aside it's not for 8A, women-owned, hub-zone, or service-disabled, but you do have to be small. There are no requirements for that joint venture agreement for what needs to be in there. You do have to ensure, of course, that everybody in the joint venture is small and potentially that all the sizes added together do not exceed the size standard. If you're going after one of these socioeconomic set-asides, there are specific requirements for some of those contents for the joint venture agreement. This presentation is sufficiently brief that I'm not going to run through all those specifically. But if you're going after an 8A service-disabled or women-owned small business socioeconomic set-aside contract, there are specific regulations that will detail what must be in your joint venture agreement. Those are minimum requirements, and if you miss even one of those provisions, then the joint venture isn't eligible. So very, very important that you get those provisions right if you're going after one of those set-aside contracts. I've seen companies lose contracts simply because they missed some little provision that was required by the regulation that seemed almost pointless or unimportant, and yet they had a contract taken away as a result. So very important to get those right. Moving next to prime subcontractor teams, just so we can keep on time here. A prime subcontractor team, of course, is now that hierarchy we're talking about, where one company is a prime contractor, another company is doing a portion of the scope of work underneath the auspices of that prime contractor. And so often a prime subcontractor team is formed well in advance of the proposal submission, especially if this is going to be a major subcontractor, which is usually what we're talking about when you're forming a team, a sub that's going to do a large chunk of the work. You form it by way of a teaming agreement. And a teaming agreement is simply a binding agreement for the parties to pursue a specific government contract as a prospective prime sub-team. So it's an agreement essentially to go after the contract. It's the proposal writing agreement, the agreement to chase that contract. It's not the performance agreement. That's the subcontract. I'll talk about that momentarily. Subcontract supersedes and replaces a teaming agreement. It's typically going to be much more detailed. A subcontract is where you're going to see these FAR flow downs. And so if you've got mandatory FAR clauses in FAR Part 52, many of those clauses say, hey, you must include this clause in any subcontract or in any subcontract over $30,000. This is where you put them. This is in the subcontract that governs performance of the subcontractor's scope of work. FAR flow downs don't go in the teaming agreement because the teaming agreement is just about pursuing the prime contract. If you're the prime contractor, you've been awarded a prime contract and you're issuing a subcontract, it's going to be difficult to spend the time going through that prime contract, picking and choosing every clause that's required to be flowed down and included in that subcontract. So most prime contractors, wise ones anyway, use what's called an incorporation by reference clause. And all that is a document that says to the subcontractor, guess what, this prime contract or the subcontract includes all the clauses that the prime contract requires us to flow down to you. And you sub go ahead and kind of figure out for yourself what those are. And those have been upheld by the courts and the boards of contract appeals. You can do that. Using incorporation by reference clause saves everybody some time. You need to give that subcontractor a copy of the prime contract, or at least the prime contract's FAR clauses if you're going to do that, because they need to know what's, they at least need to have the information to be able to identify their own flow downs. Another thing that I do suggest is that if your contract includes, prime contract includes clauses that are really highly enforced and could be problematic if your sub doesn't follow them, and here I'm thinking specifically, for example, of the Service Contract Act and Davis-Bacon Act clauses regarding payment of wages and fringe benefits. I typically go beyond the incorporation by reference clause if those sorts of things are included in my prime contract, and actually call those out specifically in the subcontract text and say, subcontractor, you agree to pay no less than the Service Contract Act wage determination. Here's a copy of the wage determination. Those sorts of things, just to make sure that you're not having a problem with your subcontractor not exactly recognizing some of these really key clauses have been flowed down to their subcontract. Here's some provisions beyond the FAR flow downs that I think should be carefully considered when forming a subcontract under a federal set-aside contract. Again, I have a lot of clients that come to me and they want to do their first government subcontract, and what they say is, well, here's the purchase order I've been using on my commercial business for the last 5 years. It's great. It's only 2 pages long. It's got some nice, 8-point font terms and conditions. Can I just use that? The answer is no. You can't. It doesn't include your FAR flow downs, number one. And number two, even beyond that, once you go ahead and include the flow downs, a subcontract should, I think, at least I would highly suggest, include some provisions that are really specific in large part to government subcontracting. And so one of those is termination for convenience. The government has the right to terminate a prime contractor for convenience. That means simply because the government doesn't feel like working with that contractor anymore, ran out of funding, any old reason really, other than something that's considered to be bad faith. And so, as a prime contractor, it'd be nice to have that same right with your sub. So you can try to insert that right in your subcontract. Subcontractors will often push back on that. But one thing that certainly ought to be included, even if the prime doesn't have the right to terminate the sub for convenience, is some statement about what happens to that subcontract if the prime contract is terminated for convenience. And usually that's something along the lines of the subcontract is automatically terminated for convenience. Subcontractor has the right to do a termination for convenience settlement proposal to the government, just as the prime would. Prime will pass that proposal through, things like that. They're very specific to government contracts, and this is far outside the typical commercial world. Same with what's called pass-through dispute resolution. That's a specific subcontract provision that gives the subcontractor a right to make claims for damages that have been caused by the government, such as government delays. And because of some legal rules, which we won't get into, the subcontractor typically does not have what's called a direct right of action against the government. In other words, the subcontractor can't typically just file a claim against the government for damages caused by the government in performance of the subcontract. And so you can get around that problem by using a pass-through dispute provision, and I include those in almost all the subcontracts I would draft for the government, for government work. A pay-when-pay clause, not necessarily specific to government work, although often very important. Sometimes the government just delays payments to the prime for a reason that's no fault of the prime contractor at all. For example, about a year ago, our government shut down, wasn't paying a lot of contractors, and in turn, those contractors were going to have trouble paying their subs. And so a pay-when-pay clause simply tells the subcontractor, look, we'll pay you when we get paid by the government, but not sooner. And for small businesses, that clause like that can really save you some potential heartburn about cash flow if the sub has done their work and invoiced you for it, but you just haven't been paid by the government for whatever reason. Then that can save you some trouble. Reps and certs, representations and certifications, I include these in most agreements I draft, simply saying that your teaming partner doesn't have conflicts of interest, haven't been suspended or debarred, don't have various ethical problems, etc. These are the sorts of things that if they're drafted well, if one of your teaming partners, subcontractors, doesn't want to sign it, that's a real red flag, because this is ethical type stuff, debarment, suspension, and so on. Subcontracting limits. Subcontracting limits exist on all set-aside contracts, and they limit the amount of work that the small prime can subcontract, and there's a policy reason for that. Congress wants to ensure that when small businesses are awarded prime contracts, they don't just serve as figureheads, as pass-throughs for large businesses. There's no real policy reason for that, if primes are just taking essentially a markup on work that's being performed by large businesses but not doing any of the work themselves, growing, developing, et cetera. And so these set-aside contracts have long had specific limits as to how much work can be subcontracted. Those limits are currently can be found in FAR 52219-14. You'll see that clause in most set-aside contracts. There's a separate clause in VA set-aside contracts that imposes similar limits. There's also an SBA regulation, 13 CFR 125.6, that has the same limits. Congress started monkeying with these in 2013. The National Defense Authorization Act adopted some new subcontracting limits for service and supply contracts. Those new limits have not yet found their way into the FAR or the SBA's regulations. They are currently a matter of statute in the Small Business Act. So there's a bit of an open question as to whether what I'll call the FAR SBA rules or the NDAA rules, which of those currently apply. And I'll show you what those rules are in the following couple slides. If you ask a contracting officer, they're going to say the FAR. Contracting officer, as far as they're concerned, the FAR is the procurement Bible. That's what they follow. They could care less what Congress did. Legally, I think it's a little more complicated than that. I would argue that a statute is, trumps an inconsistent regulation, which would mean that the NDAA limits might be effective. But, my opinion doesn't really matter much. If you're doing business with the government, the contracting officer's opinion matters much more than mine. So here are the limits. I won't read these to you. You can read them yourself. But here are the limits for service contracts. As you can see, that in the FAR and SBA rule, the limit was based on the cost of the contract incurred for personnel. It's a personnel cost based limit. The NDAA has changed this now to an amount paid type limit. So it's just the amount paid on the contract no matter how those funds are expended. And that's what the limit currently is. The NDAA is currently the limit that's specified in the Small Business Act. Eventually, the FAR will be amended to include this as well. But right now, there are two different limits out there. Same for supply contracts. The FAR and SBA rule have a limit that's based on costs. Costs of the contract less materials. NDAA was really the amount paid rule. They do still subtract the cost of materials there. It's important to note that under both the FAR SBA rule and under the NDAA, a company can still qualify as a small business by becoming or qualifying as what's called a non-manufacturer, and that's the situation in which a small business provides manufactured products that it did not itself manufacture, and that's still valid. It's a separate way of qualifying as a small business. Here are the rules for general construction and specialty trade construction. These are not changed in the NDAA. They're the same they always have been. 15% of the cost of the contract, less materials. For general construction, specialty trade, 25% of the cost of the contract, less materials. And this, by the way, the 15-25% is, as the slide says, that's the amount that the prime has to perform. And so it's a prime contractor performance rule, sometimes called performance of work rule, more commonly still called limitation on subcontracting, but really two ways of saying the same thing. The non-manufacturer rule here, I do want to go through this very quickly because this rule is commonly misunderstood. Non-manufacturer rule says that even if a small business does not perform 50% of the manufacturing costs, which is ordinarily how you qualify as a small business for manufacturing, you have to show that you were going to perform at least 50% of the manufacturing costs. However, there is that non-manufacturer rule that says you can sell somebody else's manufactured product. You can perform 0% of the manufacturing costs, essentially serve as a broker, and that's okay. You can still qualify as a small business for a set-aside contract if you meet the requirements of the non-manufacturer rule. And you can see there are 5 requirements there. And the problem that small businesses run into is the 5th one, the one that's underlined at the bottom. A lot of small businesses don't understand, and I think a lot of contracting officers don't understand, that to qualify as a non-manufacturer, you must, unless the SBA has issued a specific waiver, you must supply the manufactured product of a domestic small business. So I get this question all the time. Folks will call me up and say, well, I'm qualified, I'm a non-manufacturer, and I'm going to sell Dell computers. And I say, well, hang on a second. Has the SBA issued a class waiver? What? Has the contracting officer obtained an individual waiver? And they don't understand. The contracting officer doesn't understand. But the bottom line is that in the absence of an SBA waiver, a small business cannot qualify as a non-manufacturer by selling a large business's product. Can't do it. You have to either sell the product of a domestic small business, as it says in that last bullet there, or the SBA has to have waived the requirement, either on a broad class basis, which means that the SBA has determined, hey, there just are no domestic small businesses who produce this stuff, so you can sell the product to large business because there are no small businesses, or on an individual basis where the SBA has determined in response to a contracting officer request that for that particular procurement there aren't likely to be any small businesses who can do the manufacturing. So very important. I think this rule is probably the most, one of the most frequently violated in government contracting. Every time I explain this to a small business for the first time, they say, well, wait a second, all my competitors are doing it. I just kind of shake my head and say, yeah, they probably are. They probably are. It's not very well enforced, but it is. This is the rule. It's enforced sometimes. Again, non-manufacturer will supply the end product of a domestic small business. Here's the requirements for waivers. I mentioned that waiver can be on an individual or class basis. The contracting officer is the only one who can request an individual waiver. That means for one contract, we're going to let you, get away with selling a large business product, but that doesn't apply to the next contract down the line. SBA can also, of course, waive that on a class basis. As when again said, there are no small businesses domestically who make that stuff, so we're going to let you sell a large business's product, and that's a class waiver. Again, if there's no waiver, small business does not qualify as a non-manufacturer by selling large business's product, period. That's frequently misunderstood. Ostensible subcontractor affiliation, one of the last things I want to talk about here today, but this is something that comes up quite a bit when dealing with prime subcontractor teams. Ostensible subcontractor affiliation means that the SBA believes a small prime contractor is affiliated with its subcontractor for purposes of a set-aside contract. It arises essentially when the SBA believes that the subcontractor has too much control over the prime-sub relationship. And so that could be because the prime is considered to be unusually reliant on the subcontractor, or it could be the subcontractor is really the one doing the primary and vital portions of the work. And so in either of those situations, the SBA may say, well, wait a second, this subcontractor is really the one in charge of this relationship. They're not acting like a subcontractor. And because they're acting more like they're a prime contractor, we're going to add their size to the prime size and figuring out whether this team qualifies as a small business. And of course that means that if the subcontractor is a large business and their size suddenly gets wrapped into the prime size, now all of a sudden that prime sub team doesn't qualify as small for the set-aside contract, loses the contract. And so this type of ostensible subcontractor affiliation is fairly frequently protested. The SBA will decide protests by competitors who believe that their competition is unusually leaning on a subcontractor. Comes up a fair bit. It's important to avoid this or take the best steps you can to avoid it. We'll talk a little bit about that. First of all, SBA will tell you that they're going to evaluate ostensible subcontractor affiliation on a case-by-case basis, and they look at the totality of the relationship between the parties, between the prime and the sub. Well, that doesn't really tell us a whole lot, honestly. I mean, totality, they're not really going to look at everything, but what it does tell you is that they could look at anything. They basically are not limiting themselves in the factors that they might consider in determining whether there's been a violation of this ostensible subcontractor rule. However, if you go through the SBA's case law, the SBA Office of Hearings and Appeals, you'll see that although the SBA says that, hey, we're going to look at the totality of things, they really tend to focus on a handful of specific factors each time around in the vast majority of cases. And so I call those risk factors, things that the SBA repeatedly goes back to, looks at, and trying to figure out whether this ostensible subcontractor rule is being violated. I'm going to quickly run through those just so you can see where the SBA might focus its energy on evaluating whether a prime sub team violates the ostensible subcontractor rule. First, incumbency, and by this I mean that the prospective subcontractor is currently the incumbent, but they don't qualify to bid on the recompete, either because they grew too large or because they lost a certification, like an 8A certification, hub zone sometimes. Usually it's 8A. And in those situations, the SBA says, well, it's not technically wrong to use this successful incumbent as a subcontractor, but does suggest that since they've been doing this work maybe for the last 5-10 years, they're the ones who really know what's going on. They're the ones who are probably going to manage this project and really be in control. So it definitely subjects the relationship to heightened scrutiny. It's not strikes 1, 2, and 3, but it is certainly strike 1. If you're using that ineligible incumbent as the subcontractor, you got to be more careful about the rest of the potential risk factors. Division of work, this should come as no surprise, but the more work that the subcontractor is going to perform, the more likely that the SBA is going to say, well, that subcontractor is performing the primary and vital work, or that the prime's unusually reliant on the sub. Now, keep in mind, this assumes that you're meeting the subcontracting limits. There's going to be another problem if the sub's doing 80% of a services contract. Well, that relationship just doesn't qualify under the limitation on subcontracting. But within the bounds of the limitation on subcontracting, 49% is a lot bigger than 10%. So if the sub's doing 49%, that's okay by itself probably, but it's more likely to be wrapped into that totality of the circumstances analysis as a potential ground for finding ostensible subcontractor affiliation. The SBA will also look at the complex and important functions under the contract. That really gets to the primary and vital piece of the contract that I talked about previously. The SBA is going to be asking themselves, what's the agency really buying here? And so when small contractors tend to run into trouble is when the division of work shows that the small prime is maybe doing some management, some administration, but they're not doing whatever the agency is buying. So if the agency is buying, forensic accounting services, the sub's providing all the accountants and doing all that work, and the small prime is only doing the management, administrative, back office type functions. And the SBA says, well, that's, there's nothing wrong with that. I mean, in order to do forensic accounting, you've got to have management, you've got to have administration, but what we're really buying is the accounting. The other stuff's ancillary. And so the SBA will look at that, especially in a case where more skill and more knowledge is required to do what the subcontractor is doing. Management responsibilities, here's one where I can tell you that there's a guaranteed problem. If the subcontractor has the top project manager, whatever you want to call them, often a project manager, program manager, whatever you want to call that person, but the top employee who's running the contract on a day-to-day basis, if that person is on the subcontractor's payroll, that's probably a game, set, match right there. You've got yourself an affiliation because, prime subcontractor relationship is supposed to be a top-down relationship with the prime in charge. If the sub's employee is the one actually running the show, well, then the sub's actually in charge of that relationship on a day-to-day basis. So that doesn't mean the subcontractor can't have some sort of managerial role. Sometimes a subcontractor's employee is even a deputy project manager. I've seen that pass muster. But anytime you've got a major subcontractor, you got to make sure that their employee is not the top project manager, and you also want to have an organizational chart to the extent the sub's going to participate in management that shows the sub's employees ultimately must report up to the prime. That it's the prime's employees who are making those decisions ultimately, even if the sub's assisting at some lower level. The SBA will also look at the experience and expertise of the parties. Again, this is not to say that your small company needs to have more experience than your large subcontractor. That's often not going to be the case. Often the prime is going to be less experienced in the set-aside world than their subs are. But it does become a problem when the prime really doesn't have any relevant experience at all. And so if you see for example, a proposal that's submitted by a prime sub-team and it requires 5 past performance references and all 5 are for the sub, and the prime just can't show that it's ever won or performed a contract remotely similar in scope or size to the one that's at issue, but the subcontractor has all sorts of worlds of experience in that sort of contract. That's when the SBA starts to say, well, geez, there's just no way that this company could have won or performed this contract without sub. It looks to us like potential affiliation. That's a factor the SBA has actually been focusing on more in recent years, is relative experience and expertise. So important to not bite off really more than you can chew as a small prime. Transferred personnel, that's a situation in which it typically applies when you've got an ineligible incumbent. When the small prime says, well, yeah, what we're going to do with you, small ineligible incumbent, is we're going to take 51% of your people, move them over to our payroll, and the remaining 49% stay on the subcontractor's payroll. That will comply with limitation on subcontracting. We're good to go. You can do that, but of course it does suggest that the small prime is not really bringing anything to the table of their own. They had to get all the employees from the subcontractor. This factor is less of a concern in the wake of this right of first refusal you may have seen that was adopted by executive order several years ago, recently found its way into the regulations. That's for service personnel. But if the small prime's hiring all of its managers, its project manager, et cetera, from the sub, those employees do not fall under the right of first refusal, and those can still be considered to be potential indicia of affiliation. That's all I've got. I know we walked through this pretty quickly. I'll be happy to take questions at this point. I do want to point out, if you have questions you want to reach me offline, you can reach me there. My telephone number, email address. I do encourage you, if you haven't before, go ahead and visit my blog, smallgovcon.com. We walk through 2, 3, 4 important cases or news items happening in the world of government contracting each week. Really try and write these from a lay perspective. It's not chock full of legalese, but to kind of explain what small contractors need to know about what's going on in this highly regulated industry. It's all completely free. You can sign up for our monthly newsletter too. We round up 5, 6 of the most interesting items that are going on, send that to you, free electronic newsletter as well. So thank you very much for your time and attention. Really appreciate it and the opportunity to speak with you today. And at this point, I'll open the floor for questions.
Steve, got a few questions, and a couple of them relate specifically to this last discussion that you had on the ostensible subcontractor affiliation rules. And my first question on that is, in working both with minority-owned businesses and companies that are joint venturing and teaming with small businesses that are in the 8A program, I've heard quite a few folks that will refer to, the super sub situation, which is, you've got the 8A business and they're partnering or looking to partner with a large company that has a lot of experience with government contracting work, either through a joint venture or a teaming agreement, and they'll refer to that, larger company as a super sub. And I've cautioned clients on this in terms of being careful about the way they describe it, and not just structure it, but also how they describe the relationship, because it seems like that terminology is at least on some level in conflict with the ostensible subcontractor affiliation rules. Can you speak to that?
Yeah, I think that's right. I mean, there's certainly no exception in the 8A rules that says because you're 8A you can have a quote-unquote super sub or rely any more on your subcontractors than anyone else would. There is the special 8A mentor-project joint venturing capability, which allows an 8A to joint venture with an SBA-approved mentor, which could be a large business. As long as the SBA approves that, then you don't need to worry about affiliation with respect to any contract that joint venture goes after with the SBA's blessing. But beyond that, yeah, I would be wary of that. The SBA, the 8A rules are the same as any other set-aside program with respect to size. In order to qualify for an 8A contract, you have to qualify as a small business. In order to qualify as a small business, then you need to avoid ostensible subcontractor affiliation if that affiliation would push the prime over the size standard. And so if you've got a large quote-unquote super sub, and you're, part of it is perception. If the proposal refers to them throughout as a super sub and it makes it sound like they're so important, and I get it, there's kind of an inherent tension in writing the proposal in a way that you think is most likely to appeal to the contracting officer and make that contracting officer want to award the prime contract, but by the same token, using some of that terminology could come back to haunt you when the SBA, if the SBA reviews a ostensible subcontractor rule challenge. And I know there were, just to finish out the thought, there were a series of cases several years ago in which the SBA had actually held as a matter of law that using terms like, that suggested a joint venture-ish type relationship was actually, as a matter of law, indicative of ostensible subcontractor affiliation. They since backed off that and said, well, we're going to look at how the relationship actually runs rather than the terminology these non-lawyers have chosen to use. However, that tells you that the perception piece had made it so far that it was actually part of the law for a while as far as the SBA was concerned. So I would be very careful about that.
Yeah, thanks. And then this question from one of the attendees really gets to more of the substance of the relationship. And the question is, how do you structure a prime-sub team where the sub, is the organization that has the expertise, is the expert in a particular field that's the subject of the contract?
And again, I guess, I don't know if the question is still there, are we talking about a situation in which there is no other company that has the expertise, that the sub is the only company out there that has the expertise to do the work?
I think the context of the question is more of, you've got a situation where the sub is really the two organizations between the prime and the sub. It's really the sub that is the one that has the particular expertise. And in the context of these webinars in the arena of telecom and technology, that this is very likely to be the case in many situations. Or and it may not be the attendee actually just sent in a clarification. It may not be the organization itself, but it may be an employee within the subcontractor that has that particular expertise.
Yeah, and again, I mean, I think it's important to keep in mind that this is one of many potential risk factors for ostensible subcontractor affiliation, and it's always going to be relative. And so, the SBA does not expect that the prime necessarily has more expertise than the sub. It is potentially going to be problematic for you, though, if the subcontractor has essentially all the experience and the prime has none, no matter what the field is. And so, I don't know that I have quite enough information to answer the question, other than to tell you that depending on how that relationship is set up, it's definitely, there's a potential risk there. I would certainly mitigate that as best you could by avoiding the other risk factors we talked about to the extent possible. There may be some other ways. If we're talking about a specific employee of the subcontractor, can you acquire their services, as a 1099 for, instead of as an employee of the sub for this particular procurement, some other way to do it. There are creative ways to do it on the front end that might reduce your odds. You'd want to look at how your proposal is structured too. If you're able to submit past performance references for both prime and sub as opposed to just the prime, that can help, or just the sub, that can help. And so it's certainly something that I would think about carefully how you want to address that going forward. If you do it right, you probably have a pretty good chance of avoiding an affiliation, but you certainly are starting in a place where you want to tread a little carefully.
Yeah, and I'll add to that, I'll point out, in order to get the 8A designation in the first place, the small business owner is going to have to demonstrate a certain level of competence or expertise in the particular, in a particular field. But I could see this coming up, for example, if you had, a native-owned business that is performing IT services, information technology focused, and the individual has the expertise in information technology, but then they want to, joint venture or enter into a, subcontract with a company to come in and provide telecom services, which is related to IT, but very different in many, many levels, both in terms of the technology as well as regulatory requirements. And so, it's related to what they were doing originally, but now it's something where they really need to find a subcontractor that has that particular expertise that they don't have. And what I hear you saying is that that's one of many factors that will be examined, and they just need to go through the list and make sure that the overall structure is not such that they would run afoul of the affiliation rules.
Yeah, well, I think that's exactly right. That is often where I see this come up, especially in the cases is where, once you've got your 8A, you did qualify with, SBA reviews the company, make sure that the company's principals and the company itself have experience in the primary NAICS that it's being qualified for. But of course that, once you get the 8A, you can bid on a contract in any NAICS. So you're not restricted to bidding on the contracts that come up in your primary. And so I do see that this type of expertise experience thing come up, in which a company that, it may not be a brand new startup, it may not be a company that doesn't have any clue what it's doing in procurement generally, but they're going after a type of contract that requires a different type of expertise and a different type of NAICS code than what they've done in the past, and bringing on a sub that does have those qualifications. And so, yeah, you could think about a situation just, and you talked about telecom, and I think that's a good one. I think I saw one case where maybe it was like a food services company was going after a construction contract. I mean, something that's pretty, and they're not always that blatant, but you can see where the SBA would come in and say, well, wait a second, just because what are you bringing to the table other than the 8A certification or other than the small business certification? That's a question you got to be prepared to answer.
Yeah. And then Steve, if you could take just a few minutes and kind of on a very much higher 20,000-foot level, just kind of speak about the overall climate for federal contracting. We've gone through some very interesting years with significant fundings coming out of the Recovery and Reinvestment Act, but then with the sequester going into effect, what does the current climate look like, and what do you see as happening over the next year or so in the area of government contracting?
Yeah, I mean, I think that the current climate is, it's certainly not as good as it once was. It's not as bad as I think some folks expect it to be, but it's a tough environment. The reason that it's tough is because funding has decreased, and so the government is still making, I think, a strong commitment to small business. In fact, this year, government announced that in the last fiscal year, they actually reached that 23% small business goal for the first time in 5 or 6 years. It's been some time, and that's a great thing. Except when you look at the numbers, you see the total dollars awarded to small business were down significantly off their peak just a few years ago. And so what that means is that there's an environment in which small businesses are still growing and thriving, but there are fewer dollars to go around. And during the boom times, when funding was increasing every year, and it went up a lot, from 2000-ish up till about 2-3 years ago, funding had just gone up exponentially. And what that did is it brought a lot more contractors into the government marketplace, especially in 2008, 2009, and there was a bit of a collapse in the commercial market, so contractors were looked to the government, said the government has the money, let's get into government contracting. So what it's meant, I think, is an environment in which the government is still a great customer, it's still a good environment to be in, especially if you're selling the right product or service in the right place, but it also can be a very competitive market. And we've seen, I think, an uptick in protests and challenges and contractors fighting for every dollar that's out there because there just aren't as many to go around right now. And so I don't have any insight as to what direction funding is going to go. It doesn't seem like it's going to be a significant increase anytime soon based on the whims of Congress, although over the long term it always has increased. But I will say that on the positive side, the government is still pushing hard, I think, to prioritize small businesses, to ensure that small businesses are getting a fair chunk of the contract work out there, to put their money where their mouth is in terms of supporting these socioeconomic programs, and then even to improve and increase participation in some of these programs as well. And so it's not a perfect time to be a government contractor, but it's not the sky isn't falling either.
Yeah, thanks, Steve, and thanks to everybody for attending today's webinar. Be sure to visit the Tribal Telecom Conference website for updated information on the 2015 conference, including information and bios on our keynote speakers, and to register or find out information about sponsoring and exhibiting opportunities. We've got 2 programs scheduled for November, both of which will be presented by USDA's Rural Utility Service on November 4th. We're going to have a webinar on USD funding for telecom infrastructure, the Substantially Underserved Trust Areas Initiative, and the Rural Utility Service Telecom Loan Programs. And then on November 18th, we will have a webinar on USDA grant funding for broadband and telecom, community connect, and distant learning and telemedicine grant programs. You can also find archives of past webinars on the website as well. And then finally, please take a couple minutes to complete our post-webinar survey and help us select future topics that will be most beneficial to your community and organization. Thank you again for attending today's webinar, and enjoy the rest of your day.